Hi, this is a practice rehearsal for ASBH 2025. So this is Legal Update 2025, Top 10 Legal Developments in Bioethics and Public Health. I'm Thaddeus Pope, and I have nothing to disclose. In the next 14 minutes, I'm going to give you 6 updates. Update number 1, brain death. Now, brain death is problematic apart from the transplantation issues that aren't discussed. We've seen more conflict and more court cases. One of the big 7 problems with brain death is that the UDDA, the law on brain death, requires that clinicians determine brain death in accord with accepted medical standards. But which medical standards are the accepted ones you're supposed to use? It's hard to know because there's so much variability from hospital to hospital to hospital. To fix that problem of non-uniformity, some states have started getting rid of this accepted medical standards language. Instead, they're pointing specifically in their laws to the guidelines from the American Academy of Neurology and the American Academy of Pediatrics. First, Nevada, also New York, and New Jersey all did that. And then a few days ago, this article was published indicating that 4 more states have clarified the appropriate standards to use. So now we have 7 states pointing specifically to those guidelines. The second of 7 big problems with brain death is that there's a duty to accommodate, at least in these 4 states. And those laws are being enforced. So this is a case that's ongoing in New Jersey, where the claim is that the hospital failed to recognize the religious objections of the patient. And this is a case in Los Angeles, California, arguing that there was a failure to accommodate the family there. That's update 1, brain death. Update 2, supported decision-making. So patients who seem incapacitated often aren't. They can make their own decisions with support. So this is the notion of supported decision-making. 30 states now recognize a formal arrangement where you can appoint a supporter in addition to appointing a healthcare agent. In 2025, those states were joined by Hawaii, Utah, Connecticut, and New York already had a statute, but it promulgated implementing regulations. On top of that, the new Uniform Healthcare Decisions Act redefines capacity. It says that a patient has capacity even if they cannot decide independently, so long as the patient can with a supporter. So the Uniform Healthcare Decisions Act has already been adopted by Delaware and Utah, and probably next by Hawaii and Nevada. So that's update 2, supported decision-making. Update 3, supplanting surrogates. So the job of a surrogate is to make decisions in accord with the patient's preferences, goals, and values. But we know surrogates are not good at that. And when surrogates persist in not doing their job, they should be fired. So here are 3 new cases. Case 1 from Detroit. Linda Polk faked an advance directive, then based on the authority in that advance directive, directed the withdrawal of life-sustaining treatment from the patient to obtain his property. She's now being charged with murder. Case 2 from Los Angeles. Elvis, remember Elvis? In 1967, he married Priscilla, although they divorced by 1973, and Elvis died in 1977. Lisa Marie, his only daughter, inherited basically all of the Elvis property. In July 2023, Lisa Marie died, buried in Graceland. Last month, we get this lawsuit, which basically says that Priscilla pulled the plug on her daughter, Lisa Marie. She pulled Lisa Marie off life support despite clear directives from Lisa stating otherwise. And again, it's about the money. Lisa Marie was about to remove Priscilla as trustee from some Elvis businesses. So this is Lisa Marie's advance directive. And you see, I want my life to be prolonged as long as possible. LMP, Lisa Marie Presley. So we'll hear more about that lawsuit, although Priscilla already discusses it in her new book. Case 3, also from Los Angeles. Wallace Annenberg, an 86-year-old billionaire philanthropist, inherited much of the money from the publishing empire that published TV Guide and 17 magazine. In 2023, she completed an advance directive here, appointing Vicki Levine as her healthcare agent. Here's Vicki Levine. Fast forward to July 2025. Now Wallace Annenberg dying of lung cancer. Although Vicki Levine, not a good agent. She overmedicated Annenberg with narcotics and opioids, which the patient rejected in the rare moments she was lucid. The agent isolated the patient from her family and staff and forbade nurses from documenting all those opioids and narcotics in the medication record. And then made comments like this about the patient. She's like a cockroach. She won't die. So, the family goes to court to remove and replace Vicki Levine as the healthcare agent. And this is provided for in California law. A petition may be filed declaring the authority of an agent terminated. And that's what the court did, finding good cause to suspend Vicki Levine. So to recap this, you can and should replace bad surrogates. That's update 3, supplanting surrogates. Update 4, unrepresented patients. So patients who seem unrepresented usually aren't. You need to make a diligent search for potential surrogates who can speak for the patient. So one case here from New York. This person was hit by a New York City subway. The hospital treated her as though she were unrepresented. The family says, look, you could have easily identified her and found us, and we could have come and spoken on her behalf. And in fact, the family's claims have reached some measure of success in their ongoing lawsuit this summer. Case 2, the Uniform Law Commission is amending the Uniform Anatomical Gift Act to perhaps clarify the amount of due diligence that's required before deeming a patient unrepresented. So to recap, make sure the patient is actually unrepresented before treating them as such. Now, some patients are truly unrepresented. How do you make treatment decisions for them? Well, in 2025, North Dakota expanded its default list of surrogates to add interdisciplinary team when no other surrogate is reasonably available. New Jersey expanded when courts can appoint a special medical guardian. But on the other hand, unfortunately, Massachusetts and Minnesota, again, unable to enact default surrogate laws. Some of the only states in the entire country with no default surrogate law. And when you don't have default surrogates, you have more unrepresented patients. Yeah. That's update 4, unrepresented patients. Update 5, medical futility. So let's start in Texas. In 2023, the Texas legislature amended the Texas Advanced Directives Act with HB 3162. That required that when hospitals use the special dispute resolution mechanism, they need to report that to the state. Well, the state has started publishing reports summarizing that hospital data. Now, Texas has long been a leader in this space, and now they're followed by the Uniform Health Care Decisions Act, which says when an objecting hospital, the objecting hospital has a duty to transfer, but that duty to transfer is time limited. So they only need to provide life-sustaining treatment until a transfer or until a certain number of days after the hospital determines transfer cannot be made. So in Delaware, you only have to continue life-sustaining treatment for 15 days, and in Utah for 10 days. But the real activity has been in the courts. So Art talked about the Gray-Shara verdict, but on top of that, the hospitals just have had a winning streak here, right? Arkansas Children's got an injunction allowing it to withdraw treatment over parental objections. The hospital won in Texas here, in Illinois, in Nevada. But what's coming up next? Well, there's a case scheduled for trial against Cedars-Sinai. This one for a unilateral DNR order. But the real exciting case, I think, is this Michael Hickson case. So that is scheduled for oral argument before the U.S. Court of Appeals for the Fifth Circuit in just 2 weeks. And what we'll learn is what is the application of disability discrimination laws in the medical futility context. That's update 5, medical futility. Update 6, conscience-based refusals. So clinicians are allowed to say, no, I don't want to do that. That's clearly built into all 12 MAID laws and into each state's Health Care Decisions Act. But these states here in red, there's clinicians and entities have plenary and total power to refuse. Permission to refuse participating in anything that would violate their religious, moral, or ethical beliefs. In 2025, those states were joined by Tennessee and Idaho, and Arkansas already had a conscience refusal law, but it expanded it this year. But perhaps the real action is at the federal level. So OCR, the Office for Civil Rights, has been vigorously enforcing federal conscience laws. Now, a lot of that focuses on abortion, gender-affirming care, and vaccines, but OCR also protects conscience rights in any other lawful health service. And that may get amped up with President Trump's new Religious Liberty Commission. That is charged with examining threats to conscience protections in the healthcare field, which was confirmed in some of the RLC's early hearings. So that's update 6, conscience-based objection. I've given you 6 updates: brain death, supported decision-making, supplanting surrogates, unrepresented patients, medical futility, and conscience-based objection. Thank you.